decided to sue. And when she did so, when they were defending the lawsuit, they went and found her laptop and were able to retrieve emails that she had sent from that laptop and use them to defend themselves in the sexual harassment lawsuit. She was not too happy about that, so she sued for violation of her right to privacy. In this case, the Supreme Court for New Jersey held that, in fact, the employer had violated her right to privacy by viewing her emails. Why was this case different than the Kwan case? Well, number one, the right to privacy in the workplace is always based upon whether or not the employee has a reasonable expectation of privacy. Here, the court found that she did have a reasonable expectation of privacy. Why? Because, one, she was communicating with her attorney where she believed that there was attorney-client privilege and no one else could read what she had written to her attorney. That was her belief, right? And she also communicated with him not on her work email, Miss Stengart, at lovingcareagency.com, but rather missstengart@gmail.com, right? On her private password-protected email, albeit it was sent over the employer's server. So based on those two things, the court held that she did have a reasonable expectation of privacy and that the employer was prohibited from reading those emails and using those emails it had retrieved from her laptop to help defend them in that sexual harassment lawsuit. The difference in these two cases is that in Kwan, the employer did have a legitimate business interest in monitoring the emails because it was looking for overusage of the text plan minutes, and the search was very limited. In this case, the Stengart case, her communications were with her attorney, protected by attorney-client privilege, and sent over a password-protected private email account. So, in this case, the court looked at the employer's policy. They said the fact that it disclosed that they would be monitoring emails was insufficient to negate her reasonable expectation of privacy. Why? Because the policy did not specifically inform the employees that the company stored and could later retrieve copies of private web-based emails. And the court found the policy did not expressly state that the company would be monitoring email communications made from employees' personal email accounts when they were being viewed on company-issued computers. So therefore, the court in this case held that she did have a subjective expectation of privacy in those communications sent from her personal web-based email account, and that the employer's policy, monitoring policy, was not sufficient to quash that expectation. Virtually the same case, Holmes versus Petrovich, but in California. In this case, again, the employee had been communicating with her employment attorney via email. The employer viewed those emails, and she sued for violation of her right to privacy. In this case, though, the California court held differently. They held that the employer had an email, electronic communication monitoring policy. So the employee was aware that other people are going to be reading those emails that you send, and she had decided to send those emails to her attorney anyway. So they used an analogy, and they said, you know what, if you decided to talk to your employment attorney in our conference room with the doors open in a loud voice and other people overheard that conversation, you would lose attorney-client privilege. That's what happened here when you decided to send emails when you knew others would be reading those emails and monitoring emails. So they held, therefore, you did not have a reasonable expectation of privacy, and it did not violate her right to privacy. So it appears that it's very important to make clear in both your social media and email monitoring policy that you will be monitoring personal email accounts, personal blogs, personal posts to social media sites made while at work on the employer's servers. You also want to state that information that an employee posts on social media sites can be stored and maintained and later accessed if it was done over your servers. Now, very interesting, all of these. So you need to be aware that how you access what your employee posts on social media has a lot of legal implications. But as I said earlier, perhaps the law that has gotten more publicity than any other law with regard to what an employer can do and not do when someone posts something on Facebook or social media is the National Labor Relations Act, a very important law that limits an employer's right to terminate an employee for a Facebook or social media post. So this law prohibits employers from interfering with what is considered to be protected concerted activity. What is protected concerted activity? It is when employees gather together to discuss their working conditions and their employer. Some of the protected Section 7 activities include the right to engage in union organizing activities, like discussing wages, hours, and other terms and conditions of employment. So under Section 8A1, that is the section that would be involved in these types of cases. That section of the National Labor Relations Act prohibits employers from interfering with employees, again, when they engage in concerted activity. So an employee post on a social media site that focuses on talking about protected concerted activity that they have a right to focus and talk about would be protected. And the National Labor Relations Act allows employees to do this because it is a necessary activity, one they may engage in pursuant to their right to bring in a union or vote for a union. Now, you might be thinking, well, we're not a unionized employer, so this law doesn't apply to us, right? And the answer is wrong. You might not realize that this law actually protects employees' right to do this, whether or not there is actually a union in place in your workplace. This right exists in all workplaces, unionized or not. So the NLRB, especially the Obama administration NLRB, ended up filing charges against many, many employers, alleging one of two things: either that the employer's termination of the employee for what they posted on social media in some way violated the National Labor Relations Act, or they allege that the employer's social media policy in and of itself violated the National Labor Relations Act. So, just the National Labor Relations Act issue could take up an entire webinar, but what I want to do is provide you a brief overview of this issue in today's webinar. So the General Counsel of the NLRB has actually issued 3 separate memos in which he discussed many of the cases that the NLRB brought regarding this issue. So one of the most popular cases that attracted national attention, and that helps me explain to you what this issue is all about, is the Connecticut Facebook termination case. In this case, the NLRB filed an unfair labor practice complaint against the employer, who was an ambulance company in Connecticut. The NLRB alleged that the ambulance company had violated the National Labor Relations Act when it fired its employee because she had posted negative comments when she was at home, not at work, from her home computer on her Facebook account. She posted those comments about her supervisor. The NLRB alleged that when she posted those comments from her home computer, they constituted protected concerted activity. And of course, as I said, protected concerted activity is the right that all of your employees have, whether you have a union in place or not. Any employee in any workplace in this country has this right to gather together and discuss the terms and conditions of their employment without any interference by the employer. So, and as I said, employees have this